Have we found the law which made Britain woke? If you accidentally call your colleague by the wrong name, is that racial discrimination? If you make a joke about India to a friend at work, is that racial discrimination? If you ask your employee to get back to work when they've left early, is that racist? All of these cases were found to be so under the Equality Act. Don't Divide Us have done an analysis of thousands of cases tried under it and have found a deterioration in race relations at work, infringements on our freedom of speech, and huge costs for businesses and government resulting from the Act. One council has even gone bankrupt, in large part to a £1 billion ruling against it. The author of the report, Alka Sehgal Cuthbert, is here to tell me more. Do you think that the Equality Act could be seen as an example of cementing two-tier law in Britain?
Yes, I think it does. I mean, I think at its heart there's this contradiction within its wording, which is that on the one hand it prohibits segregation, that's section 13.5, yet on the other hand it also has to actively promote equality under the public sector equality duty, and at the same time you have protected characteristics, which invites us all to present ourselves in terms of groups with alleged disadvantages attached to that grouping, that group membership. And then you have very little insulation between the legislation and wider political culture and activism. So although technically or formally we all could slot ourselves into a group, those groups are not equally given equal cultural status. And that impacts, we're seeing our report shows how that is beginning to impact on some of the tribunals' judgments in their thinking.
And so could you tell me a little bit more exactly how that plays out?
Yes, so for example, in one case, which is in our report, it's one of the example cases, the judge reports that in this particular case, I'm sort of paraphrasing, he says, even though objectively the claimant doesn't really have a case, the claimant's feelings were authentic and genuine, and because the claimant belonged to an ethnic minority group, and that historically ethnic minority groups have suffered discrimination, his feelings had to be taken into account. So that's really prioritising a subjective test to assess feelings on the first hand, and it's also uncritically accepting a historical narrative of oppression that comes from identity politics, and that is being prioritised over the objective tests that are still being applied in a large number of cases, thankfully, but nonetheless it's worrying that we can see it being demoted.
Do you remember exactly sort of what happened in that case?
In that particular case, it was yes. So it was in a hospital. The NHS is one of the largest employers and also one of the largest employers in cases that we've looked at. In that case, it was a hospital porter who was so he was the ethnic minority. I think he might have been Pakistani, and his line manager is a white woman, and he was known he was known to just generally be somebody who, would be difficult to find quite often. They might, in a ward, they might be, somewhere else in the cupboard or in another little room somewhere, and so therefore kind of like a little bit of a not the most conscientious, let's say, of workers. And what happened was, his shift was about to end, and he went in before his shift ended. He went into the changing rooms. Now the ward manager was looking for him because she was for whatever reasons, maybe they were understaffed, I can't quite remember, but she wanted him there to ensure that the handover to the next shift would go smoothly, and some patients had to be moved to another ward before the handover. So she was kind of quite, if you like, stressed trying to find him. And when she found him, she spoke rudely to him. She was quite sort of like, "Come out here, we need you now. What are you doing?" And he claimed he had to go in and have a sandwich because it had been Eid and he'd been fasting. And that was why he'd gone into the changing room. So that was, if you like, the initial kind of scenario that then kind of rolled out from there in terms of the complaints lodged back and forth, etc. And he lodged a complaint against her, and then she retaliated, and it ended up in the courts. And that was what the judge said she lost. Yeah.
Wow. Do you think that, I mean, a lot of the issue that our viewers have is that people feel as though the state has some kind of bias against straight white men these days, and it looks as though when you look at the protected characteristics in the Equality Act, they don't seem to be listed anywhere. And so with this idea of potentially there being two-tier law in Britain, is there a case that the interests of other groups are being put above the majority group?
This is what multiculturalism is. I mean, multiculturalism is involves the demotion of the majority culture, because by default, by being a majority, it's considered to be not equal, for not offering equal opportunities or recognition or status to those from a minority group. So the idea is to demote or devalue the majority culture so that it sits, if you like, on a horizontal plane of other groups, to be, presented in legal and formal official terms in that way. But then you have identity politics that then is really pushing for additional cultural status and value to be put on certain particular groups on that horizontal plane because of their alleged oppression, historical oppression, right? So, I'm from India, that was a former colonized nation, but there is absolutely no way that me as an individual Indian woman, a British citizen in Britain in 2025, is oppressed or disadvantaged in any way. I mean, the idea is just ludicrous. So that is what is that, there is a rational kernel to the idea that, if you like, it's white working class straight men that are being discriminated against. I don't think it was like originally just deliberately had them in their crosshairs, but that is the inevitable consequence of the logic of multicultural politics and identity politics in the law.
And when people see that sometimes there's training or even jobs at, say, the BBC that are being reserved for people of minority ethnic backgrounds, would that be something that's coming under the scope of the Equality Act? Is that something that the Equality Act is allowing?
Well, it's actually encouraging. It's actively encouraging through its positive action stipulation, which, as I said, that falls flatly against its own Section 13, which prohibits segregation, and that contradiction will be tested in law soon. Carol Richardson, a nurse in the NHS, is taking her employers to to court precisely to test that, because what's the difference? If barristers themselves and the courts themselves cannot give a good definition of what is positive action and what is segregation, then how are the rest of us meant to deal with this, kind of complete confusion?
And one thing that sometimes a lot of minority ethnic people or people that have these characteristics, disabled or homosexual, they will say, I'm not this group, I'm me. Do you think that the Equality Act has specifically moved us away from the idea of all equal under the law as individuals to us now being categorised into groups and then being dealt with by the law in that way?
Absolutely. It's a fundamental legal pivot away from what you've just described of equality. We all stand as equal citizens under a law that is supposed to apply to us all universally without fear or favour. That is really fundamentally tested to a breaking point, I would say, through the Equality Act, because it's really saying our access to the law is to be determined by the weight that is given by judges according to our group protected characteristics. So you can say it's universal in that we all have a ethnicity, or we all have a nationality, or we all have a sex. But when we know that there's very little boundary between the Equality Act and wider cultural and political pressures, we know that we're going to present, when we present ourselves, it's going to be, it will not be applied equally. And there's a really good example of this, because we've got the case of two people, both of whom had their beliefs validated by the courts as protected beliefs. Maya Forstater for gender critical beliefs, and Sean Corby for his colourblind Martin Luther King beliefs, which is what Don't Divide Us also upholds. Now, but however, when Sean Corby, a white working class man, then went on to test his protected belief in his workplace, when activists in another branch of ACAS, which is who he worked for, they had never even seen him or met him, complained about him, he lost, right? So even though they both had protected beliefs, when push came to shove, one protected belief held by a white man, a working class white man, was judged to be less validity than another person, than Maya Forstater's. So, it doesn't really, some individuals might win individual cases, and we're not, I'm not against that. Good luck. People have to use whatever they can to, be treated fairly. But the overall, the costs for our society will be huge if this goes unchecked. It will be huge in terms of social cohesion and solidarity, and also in terms of workplace culture and ultimately productivity.
There were some examples in your report that I'd like to get into, a little bit about how, number one, it seems as though it can be quite difficult for an employer or a colleague to understand that they know that they're working within the remit of the Equality Act because of its subjectivity. I think there was an example that you'd put about a person who'd made a joke to their colleague who was leaving about India.
There was a case where this employee was the only non-white employee in an office with a few other colleagues, and the colleagues were white. I think they were originally from South Africa, and they'd been making jokes, and including during the jokes, doing accents, mocking accents, including the Indian accent. And that was deemed to be harassment by the judge, because of his ethnicity. The employee, I think, was actually Iranian, but it was labelled as Asian in the case, and because of his ethnicity, assumed ethnicity, some, probably not very good or offensive or clunky jokes, which, you would think somebody would say, don't make those jokes, and that would be the end of it. But no, it was kind of like the whole thing got exacerbated through the complaint system, and it ended up with as harassment being upheld on that one ground, even though this employee, in every other way, was like a terrible employee, right? They hadn't, that they had not been meeting their targets. They had not been communicating well in their performance management and things like that. But just on that one thing, so ethnicity and harassment and the regulatory burden of the Equality Act trumped all normal things that most people think are important in doing a job properly.
And there was another case in your report, I think it was with Jaguar Land Rover, where I think it was an Indian colleague had been named by, I think they'd been called by the name of a different colleague of the same ethnicity, and they were found to have contravened the Act. Do you have any idea of sort of how much, not just the cost of if they're ruled against, but also compliance, how much that's weighing on councils and employers, how much it's costing the economy?
First of all, just on that case, what happened, it's really very interesting, because it wasn't just the fact that he had been misnamed that swayed it with the tribunal. It was the fact that the employers had failed to give a good account or any account of that. It was another Polish or another East European employee who had misnamed the guy. And because the employers had not presented a statement or called her to be a witness in the trial, the judge deemed they were falling short of their public sector equality duty thing. So you can see that the Equality Act is really placing a lot of extra regulatory burdens on employers. In terms of costs, I mean, no, I don't know the figures. There have been several newspaper articles recently that have given the cost in kind of billions in terms of EDI positions, because nearly every major business and an institution like the NHS has to, is now put in place within it, not with usually separate to the HR. They have to pay for HR staff, and then they have another. They set up another, workplace group specifically for BME interests. The NHS has been doing this on a rolling out basis since 2010 of its workplace race equality standards, which is kind of justifying all these positive action schemes. But I'm afraid I haven't got figures for how much it's costing. But it's not just the cost of, you've got to remember, it's not just the cost of the paying for staff to do this or hiring a venue to organise training. When all these court cases, even if the claimant doesn't win their case, the employer will have had to trace emails from up to 2-3 years ago. They will have to look for employees, for witnesses. And, if you're in a business which has a high turnover of staff, that can be really difficult. So aside from all the legal fees, there's a huge kind of administrative burden as well on that.
And it might be worth it if it was improving race relations. Has it done so?
I don't think so. I mean, the rise in litigation suggests that no, it isn't, because, what it's doing is it's encouraging employees to see themselves in such atomized, individualized basis, that you don't, so you go to work with everything encouraging you to look for offence on the basis of your skin color. Rather than you go to work with a view to, I'm joining my fellow teacher, shop worker, cashier or whatever. And this goes across sectors. It's not, it's particularly prevalent in sectors like care work and cleaning and security work, kind of manual, lowly paid work. But it's also in, banking and the financial sector as well. So, if that is the way you go into work, expecting those kinds of relationships, then you are not going to be able to speak freely and make friends, are you? Sort of everyone's going to be a potential hurter of your feelings and a potential offender. That can't be good. And what are the employers going to do? I mean, it puts them in an impossible position, really.
So this law was Labour's kind of parting gift when they left office last time. They're back now. They're talking about reviewing, maybe widening the scope of the Equality Act or a new Racial Relations Act. Do you know a little bit about what they're thinking of doing, or do you have any fears of what might come next, or even advice for the government on how they could change and maybe walk back some of the negatives?
Well, as far as I know, they have not sort of put out in the public domain a fully worked out bill. What they are talking about is a new Race Equality Act with disability folded into that. On disability, I would say that would be the only category that I think may merit some of these positive action things, but only after we've looked at it properly, because at the moment we've got a situation where some people are claiming intense hay fever as a disability, which clearly it isn't. So it does need, but so what the Race Equality Act is proposing to do is to impose mandatory reporting of pay gaps along ethnic lines and they're saying that that's because this has worked so well in the case of sex discrimination. But I mean, it's completely idiotic because, women, for a start, make up such a huge percentage of the population, and we're more evenly distributed amongst across the nation geographically. Ethnic minorities aren't, and I think it's going to be in businesses over a certain size, possibly 250 employees, I'm not sure. But this is, what is this going to do if you're one of the very, over the 70+% of SME enterprises in Britain in an area that is not an urban multi-ethnic place? How is, the burden for you to then have to produce a report on a regular basis of what your pay gaps are and what your representation in terms of hiring policies are vis-a-vis ethnic minorities. How on earth are you going to, you're going to end up looking really, really bad because you won't have many, because there aren't many ethnic minorities in your area, or it might discourage, it might have very likely to have perverse consequences of companies saying, well, in that case, we're not going to hire, people at the lower end, at the entry level, from these ethnic groups, because that will make our figures look really bad, when we've got to hand in our report next year. It's really unthought through, and it will be really divisive. And my advice would be to just forget it, abandon it.
And would you go as far as to wanting to scrap the original Equality Act?
Well, what we recommend in the report is the immediate repeal of the public sector equality duty and positive action. And then we recommend a really thorough legal review of the whole Act itself, with a view to repealing it, yes. But as I said, the caveat would be around disability. I think that needs to be looked at, almost as a sui generis category.
That was Alka Sehgal Cuthbert from Don't Divide Us. It remains to be seen what the Labour government will do to expand on the Equality Act. Nick Dunning, GB News.